Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about the first exception to the indoor management rule. So what is our first exception? That is cases of actual knowledge. A person who knows about the irregularity can't rely on this rule because he lacks good faith and can't be allowed to presume in his favor that things are rightly done when he knows that they are not. If you have been following my lecture, this sounds more like the case of Morris versus Kansen, where we had C, S, and M who were directors of the company. M knew that he was not properly appointed. M knew also that the shares which were purportedly allocated to him was not done in proper manner. The court held that M, who was an insider, could not therefore say that he did not know. Do you understand? So here we have the Nigerian case of AFOLABI versus POLYMERA Industries. The fact is that the plaintiff claimed that he had been appointed a sole agent by the defendant to sell their products. He based his action for money due as compensation and damages for breach of contract on a letter written by Mr. Okunsoya, a subordinate employee of the company, purporting to appoint the plaintiff as the defendant's agent, that's the company's agent. The court found that neither the managing director nor any other director had proposed the terms set out in the letter to the plaintiff. And also, Mr. Okunsoya was not directed to write such a letter. The court further found that the plaintiff was maintaining a rather sinister association with some members of the defendant's staff and was wielding a somewhat unwholesome influence on them, and that such led to the issue of the letter, which looks like a fraud. The court held that no contract existed because the plaintiff knew of the internal irregularity and lacked good faith. It was held that no contract existed between the parties. Now, you see, when we are talking about exceptions, one thing you need to know is that the exceptions are not on the first leg. The exceptions are on the second leg, which is the presumption of regularity. So let us start with this, our first one, which is cases of actual knowledge, where a third party actually knows of the irregularity in a particular company. Then the court will not presume on his behalf that there has been regularity because he knew that there were irregularity. In Morris and Kansen, the purported director M knew of the irregularity. In AFOLABI versus POLYMERA, he knew that Mr. Okunsoya has not been given the authority. Whether or not he in fact can give out letters of such nature is a question of ostensible conduct, which we have to look at the memorandum. But whether that act is such that it is subject to certain conditions like the managing director must approve or the board of directors must approve, would then be the non-ostensible conduct. In this case, the plaintiff knew that Mr. Okunsoya has not been given such authority. Do you understand? Therefore, he had actual knowledge of the irregularity and cannot rely on the presumption of regularity. Do you understand what I'm saying? So that's our first exception, and there are two cases for that. So now we move to our second exception, which I'll be discussing in my next class. See you there.